So good evening, ladies and gentlemen. My name's Justin Cardy and I'm the 2017 Executive Editor of the University of New South Wales Law Journal. It's my honour to be able to welcome you all here tonight for the launch of issue 41, the first of 4 issues that will be published throughout this year. I would especially like to extend a very warm welcome to the Honourable Chief Justice Bathurst, to Ian McGill and the Partners and Solicitors of Allens, to Professor George Williams, the Dean of the UNSW Faculty of Law, and to the editorial board of the journal and our journal alumni. I would also like to welcome some of the authors who contributed to the issue that we're launching tonight. I know we're privileged to have quite a few of us here with us. Now, each issue of the UNSW Law Journal features both a general and a thematic component. The thematic component that we're launching here tonight is on contemporary professionalism and regulation. Now, each of tonight's speakers, who will follow shortly, will have a lot to say about the thematic topic. So before we start, I'd instead just like to take a moment to acknowledge the work and the effort that has gone into realising the printed journal that you have before you. There's also a number of people to thank. People whose generous assistance, whose support, continues to make the work of the journal possible. So on behalf of the journal, I'd firstly like to thank our host and our premier sponsor, Allens. Allens have been a sponsor and a very valued supporter of the journal for over 3 decades now, and their support continues to be invaluable, so thank you. The journal is very honoured and privileged to have such a long-standing relationship with the firm. So thank you, Ian McGill. Thank you for welcoming us here this evening, and also to Lauren and her team for their support in helping us organise tonight's launch. I would also like to acknowledge our other premier sponsors, Herbert Smith Freehills and King & Wood Mallisons, for their ongoing support of the journal as well. As a journal that's run by a voluntary student board, we are also indebted to the Dean of UNSW Law, Professor George Williams, and to our faculty advisors, Associate Professor Lyria Bennett-Moses and Professor Rosalind Dixon. We appreciate their wise counsel, their guidance, and the belief that they have in the students that make up our editorial board. A very special thank you also goes to the journal's editorial board, the members of which have all volunteered their time to edit each and every article in tonight's issue that we're launching multiple times through different iterations as we move towards publication. This can be a painstaking process, but the care and the diligence that each member applied to the task is a real testament to their skills. Finally, I would like to congratulate the editor of issue 41, Maximus Jones. Realising an issue of the journal is no small task. Even with the great support of the editorial board, someone will have the ultimate responsibility for driving the issue forwards, for allocating edits, making editorial decisions, organising peer review, and the copious amounts of correspondence that comes with doing that. So it's a long 12-month process, but over the past year, sharing that time on the executive with Max, I've observed the real dedication that he's brought to that role. And I must say that I've been very impressed that throughout the inevitable ups and downs of the publication process, Max has always been consistently one of the calmest and the coolest heads in the office, every time, unfailingly. Now, the metaphorical image of the duck gliding gracefully across the top of the water whilst, the feet are paddling furiously under the water could come to mind. But to be honest, Max has always applied himself with great focus, real skill, and has always been in control. So congratulations, Max. Congratulations on the issue that we're launching here tonight. It's a great achievement. Thank you for all your work and the broader contribution you've made to the journal as well. Now finally, I would like to introduce Ian McGill to speak on behalf of Allens. Ian is a partner with the firm who specialises in mergers and acquisitions, corporate governance and complex commercial contracts. Ian is highly sought after for his advice on the regulation of most sectors, of the information and communication economy and the structural regulation of converged media and telecommunications industries. So thank you, Ian. We're very grateful for your time in speaking to us. Thank you, Ian.
Welcome, everybody. This is the largest gathering at any launch of any law journal in Australia in modern times. Allens is very, very proud of its association with the University of New South Wales, which has contributed to many of the lawyers that work at the firm. We're also proud of the association with the Law Journal itself. There are a number of lawyers here, including myself, who worked on the University of New South Wales Law Journal. I see we're up to issue number 40. I edited issue number 3 in 1980. It's a gripping read. I recommend it to you. It's a very good article called "The Jurisdictional Basis of the Mariva Injunction," cited by the High Court of Australia, by me. Anyway, if you can't sleep, I'd recommend that to you. As is customary at an Allens event, I wanted to acknowledge that we meet on Aboriginal land, and I wanted to pay my respects to the Gadigal people and to their elders past and present. Reconciliation means a lot to the staff and partners of Allens, and we have had a significant role, particularly in relation to constitutional recognition, which appears to have stalled for the moment, but I diverge. We are very honoured to have the presence of the Chief Justice here tonight. I wanted to acknowledge his presence. It's a great honour to have him here to launch contemporary professionalism and regulation, the issue that Maximus has had the leadership of. Thank you. Thank you for gracing us with your presence here tonight. George Williams, the Dean of the Law School, great to have you here. Tonight's launch is a culmination, is a culmination of a conference that has occurred in the firm today on global professional firm and employed professionals. These are important topics. It's obviously important in global professional firms to have highly developed marketing techniques. So it's a little bit embarrassing. If it was me, it would be a little bit more subtle. There it is. You would have thought nearly 200 years of existence wouldn't need a sign like that. Without any further ado, as a former member of a law journal board at the University of New South Wales, congratulations to the editor. Congratulations to the board, a magnificent job, and it's my very great privilege to introduce Maximus to say a few words on the occasion of the birth of this baby.
I'm very pleased to welcome you all to the launch of Volume 40, Issue 1 of the UNSW Law Journal. I too would like to begin by acknowledging the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation, and I pay my respects to elders past and present and to any Aboriginal and Torres Strait Islander people here this evening. Each issue of the UNSW Law Journal contains two distinct parts, a general and a thematic component. This general component contains 7 articles exploring a range of contemporary legal issues. They discuss the liabilities involved when a fiduciary diverts gains to companies, regulations concerning access to and sharing of deep-sea genetic resources, wartime sexual violence and its prosecution in international law, the interrelation of military and civilian inquiries, the use and regulation of facial recognition technology, family law as an alternative system for protecting Indigenous children, and vocationalism and professionalism as approaches to legal education. Although diverse in subject matter, these articles are united by their outstanding quality, originality, and their currency. In the final article of the general component, author Nicholas James advocates an approach to legal education that seeks to shape graduates into legal professionals. That's an approach which not only develops their technical competence, but also instills ethical values and a concern for social justice. This argument ties in well with the thematic component of issue 41 on contemporary professionalism and regulation. The thematic analyses how the structures, practices, and beliefs of work have changed and continue to change in the 21st century, and it reconsiders what it means to be a professional. The professional structure is one traditionally built on trustworthiness. Governments afford professions a great degree of autonomy over their actions and the discipline of their members. And in return, professionals uphold the high standards of competency, ethical responsibility, and a culture of public service. That is a dynamic which modern developments, particularly those in the commercial sphere, have altered. Less than 2 weeks ago, the Law Society of New South Wales released its report into the future of law and innovation in the profession, or to use the more catchy name, the FLIP report. The report reflected on this change, including key observations that clients seeking greater efficiency and value are driving legal practice further towards commercialism, that technology is changing the nature of practice, and that change has brought with it ethical and regulatory issues. The same issues have been felt even more acutely outside professional groups. In the financial industry, a series of high-profile scandals, the global financial crisis, the manipulation of the London interbank offered rate, and in Australia, the ComInsure scandal reported on last year are just a few examples of how regulation has failed to prevent misconduct driven by a profit-seeking culture. With this as its background, the thematic component of issue 41 broadly seeks to address two questions. The first is whether professionalism is compatible with contemporary ideals, and if it is, what forms and structures will empower professions to uphold their integrity. The second is whether and how beliefs and structures of professionalism may be extended to other occupations, in particular to financial institutions, as a means of improving conduct and restoring trust. The 7 articles in the thematic component respond to both questions from a range of perspectives, and each makes an important contribution. Together, their message is somewhat optimistic, as Professor John Flood captures in his foreword. He writes, "Career trajectories will be different from those of the 20th century, and despite the commercial pressures inherent in these developments, they have the potential to create more space and time for ethics and the values that contribute to a better society." This issue of the UNSW Law Journal is the combined effort of many people to whom I am incredibly grateful, and like Justin, I would like to take some time to thank them. First, I would like to thank the authors, many of whom have come here this evening, for the insightful contributions they have made to academic literature. It has been a pleasure and a privilege to work with them over the last year. Professor John Flood has written an excellent foreword, and he has my warmest thanks for drawing together the threads of the thematic component so elegantly. I would also like to thank the anonymous peer reviewers whose considered comments have been both helpful to the authors and crucial for student editors faced with the difficult task of making publication decisions. I want to extend a special thanks to the authors of the thematic component who have conceived and developed its topic as part of their ongoing research project. In particular, I thank Dimity Kingsford-Smith for her guidance and communication throughout the publication process. Thank you to our wonderful faculty advisors, Associate Professor Lyria Bennett-Moses and Professor Rosalind Dixon, as well as to the Dean of UNSW Law, Professor George Williams. Their ongoing mentorship, support, and outward enthusiasm for the journal and its future development are hugely valuable and are greatly appreciated. Thank you, of course, to our premier sponsor, Allens, for hosting this evening, and also to our other premier sponsors, King & Wood Mallisons and Herbert Smith Freehills. None of this would be possible without the effort of the journal's editorial board. The students who volunteer their time to edit this journal are incredibly capable, and they're comically pedantic. Who knew that there was so much satisfaction to be had in changing a straight apostrophe to a curly one. Shavika knows. Thank you to my fellow members of the Executive Committee in particular. Your support, enthusiasm, and most of all your good humour have made the last year rewarding and enjoyable in equal measure, and it has been my privilege to get to know you all. Finally, on a personal note, I would like to give a heartfelt thanks to my friends and family, and in particular to my parents who have always supported me, and to my partner Kate, whose immeasurable generosity and friendship have helped me more than I could describe. It is with great pleasure that I now welcome our keynote speaker for this evening, the Chief Justice of New South Wales, the Honourable Chief Justice Bathurst. There's more. Before being appointed to the bench, Chief Justice Bathurst was a solicitor and a leading barrister specialising in corporate law and litigation. His Honour served as a member of the Australian Government's Takeovers Panel and as a president of both the Australian Bar Association and the New South Wales Bar Association. In 2014, His Honour was appointed a Companion of the Order of Australia for eminent service to the judiciary and to the law, to the development of the legal profession, particularly through the implementation of uniform national rules of conduct, and to the community of New South Wales. Please welcome Chief Justice Bathurst.
Good evening, everyone. Can I join the previous speakers in paying my respects to the traditional owners of the land and all other Indigenous and Torres Strait Islander people who are here tonight. Can I then offer my congratulations to everyone who's been involved in production of what is an absolutely outstanding issue of the University of New South Wales Law Journal. To each of the contributing authors, the editorial board, the executive editor, Justin Cardy, and of course the editor of this issue, Max Jones, who you've just heard of. You really should be very proud of all the work you've done in getting this issue to print. I know the stress that goes through getting one article, but a journal is impossible. I should mention, of course, because you've got to temper my praise, that I've got a vested interest in this, since I was pleased to discover that one of the authors is a former researcher of mine. I saw her early on drinking out of a bottle of beer. She used to drink wine. Things must get tough. Sorry, Sarah. I've been asked this evening to offer some of my personal insights into the topic of contemporary professionalism and regulation. Now, I practiced as a barrister in commercial and corporate law for about 35 years before I came to the bench. It was a long time. Probably a lot of people here who briefed me thought it was too long. I'm pleased to see the back of me. But it's no doubt two things are unsurprising in that. First, my relationship to the topic finds most resonance, of course, in the interaction between commercialism and professionalism. And second, I come to it not necessarily from the view of a member of a large law firm. I never was, obviously, but from a person who observed it out from the outside, but who, interestingly enough, saw the same pressures put in relation to this area, although probably because we're a one-bam practice, not with the same commercial difficulties. Now, putting it simply, we never advertised like that. But we did, particularly before taxation reform and fringe benefits tax, have large lunch and entertainment bills. I'm not going to say who at this room I entertained, they know if I ever did. But from those simple days, it's undeniable that as the practice of law and the world of commerce have increasing complexity and sophistication, so too have challenges to professional ethics. The degree to which the field of professional ethics has advanced over the last century can be seen by looking at the state of the regulatory framework in the early 1990s. There's a fascinating little book by Gleason Archer, who was the original founder of Suffolk University Law School in Massachusetts, which purported to be a comprehensive treaty on the subject of ethical obligations of lawyers in 1910. To illustrate the complexity of ethical challenges which confronted a lawyer in those times, Archer's treaty includes a chapter titled, and I quote, "Office Not a Lounging Place," in which he sternly warned his readers that a law office should not be a lounging place for the attorney's idle friends and acquaintances. That's probably true today, and indeed some of that resonated from the time that I first came to the bar. I remember appearing before a district court judge who wasn't very bright and who'll remain nameless, who said two things to me. He said, "You're slouching in the bar table and your wig's askew." Over, I think, 36, and he treated it as a very serious matter. Over 36 years, I never broke that habit. But in instructing on the conditions of office, Archer implores the office should bear witness to the presence of a studious lawyer. Books should be in evidence. If the occupant's library is small, he should arrange what books he has in the most imposing array possible. It's not necessary that all books in the collection be the latest publications. Shelf fillers are quite as serviceable when the object is to fill up shelf space. More books are all alike to the ordinary client, so far as the estimate of value is concerned. Now, you think that's out of date. These days, young people who go to the bar are confronted with sets of chambers which have got all these shelves. They've got no use for them, they work off the computer and online. So they plead people, sometimes their parents, to give them unused law books so they can fill up the shelves so private artists quote. Now, no doubt there are many corporate lawyers here today who, and I don't say like me, yearn for the days when compliance with their ethical obligations simply involved the rearrangement of their library's law reports, or indeed when they couldn't impress their clients so easily. But in the modern age, the rise of commercialism has affected the legal profession both internally and externally. As law firms have adopted fee models and corporate structures that reflect the market in which they are operating, and as they respond to their clients' call, an increasingly sophisticated call for further integration of the lawyers into the world of business. Unlike in Archer's time, when funneling lawyers into business was, in his words, a way of disposing of the overflow, lawyers... I'm sorry, it's true. Lawyers are our integral players in corporate decision making, and in many ways essential to facilitating efficient business operations. This environment of commercial immersions is something Justine Rogers, Dimitri Kingsford-Smith and John Shello discuss in their article on this issue, noting how the corollary of the fact that large law firms, I quote, facilitate almost every economic activity and business transaction in society is that they are also in a special position as ethic gatekeepers with the ability to advise the client against wrongdoing and potentially withhold their cooperation. Now, they talk about large law firms, but can I assure you it's not only the large law firms who face those challenges. Every lawyer is commonly asked for advice on matters which have interrelated legal and commercial questions. A lawyer cannot in these days isolate him or herself from the commercial consequences or effect of the advice given. I have the privilege as a sole practitioner of having a retainer from a number of large corporations, and they don't need to be mentioned, but some of the larger corporations in this country. One of the most interesting retainers I had was to advise not the company, but the board of directors of the company. It was a direct retainer of the board. And as a result of that, I attended board meetings in rooms which I discovered to my surprise was carefully wired to prevent people from eavesdropping from outside. But the interrelation and the importance of the legal aspects of decisions both in this country and things that vitally affect them really demonstrated to me in a very serious way how important this interaction is. Now, courts always, I shouldn't say this, but I will, courts always lag behind to some extent, but the role of the lawyer as a gatekeeper is something that's been, I think, increasingly recognised by courts as they find ways to hold lawyers legally accountable for illegal actions of their client. I'll just mention two cases, ASIC at Somerville and Saffron and ASIC. In Somerville, ASIC brought a civil penalty action against Mr Somerville and 8 directors of companies advised by him. While the directors consented a declaration of the breach of directors' duty provision of the Corporations Act, Mr Somerville, through his legal advice, was found to be accessorially, I can never use say that word, liable under Section 79 of the Corporations Act. In Saffron, of course, James Hardy's in-house counsel was captured as an officer of the corporation and thus found liable for breach of duty under Section 180 of the Corporations Act. The fact that Mr Saffron was both General Counsel and Company Secretary is a perfect example of the increasing overlap between law and business. This entanglement of lawyers in corporate action and the court's willingness to impose liability on advisors in such a position demands that lawyers no longer stand passively by their clients' misdemeanours. As Elihu Root, a prominent New York attorney and later, of course, United States Secretary for War, famously stated, about half the practice of a decent lawyer is telling would-be clients that they're damn fools and they should stop. It's not bad advice sometimes, and it's still not bad advice today. But the question of where the line is drawn and what interventionary action is required throws up some very challenging questions. The breadth of the spectrum of possible intervention is evident in the variety of metaphors used to describe the relationship between lawyers and their corporate counsel. In questions of whether lawyers should simply refrain from encouraging unethical behaviour, or whether they should actively dissuade, withdraw, or report, internally or externally, commentators have asked whether the role of the lawyer should best be described as guardian, gatekeeper, watchdog, or whistleblower. But of course, as progressively positive obligations of reporting are imposed on lawyers, the greater the likelihood of conflict with their obligation to the client, and of course particularly that of confidentiality. Archer advised that a lawyer never loses but gains by severing his relations with a client who turns out to be a rascal. Very useful book, actually. Unfortunately, this advice was, of course, more effective before competition and consumerism because it became the guiding regulatory force. And it was one advantage of being a commercial barrister, I think. You could always say no because people would turn up again sooner or later. But as Rogers, Kingsford Smith and Shelley discuss, the free market deregulation of the 1980s left its mark on the profession with a distinctive client influence over the meaning of professionalism. When clients were able to shop around for the right legal advice, the ability to deter unethical corporate behaviour is severely weakened. In Hugh Breakey and Charles Sanford's article, they show us how this phenomenon is not confined to the demands of corporate clients, but also those of powerful employers, including governments. They cite one of the best well-known examples, and that was Madeleine Albright's exhortation to the United Kingdom government to get new lawyers when they received the first advice concerning the legality of military action in Kosovo. Now, you might say that there might be some advice going around the West Wing of the White House at the present time. I probably shouldn't go there. In Graham Greenleaf's review of Richard and Daniel Susskind's The Future of the Professions, we see how the influence of competition and client-related legal services may be exacerbated in the future. For instance, what happens to legal professionalism when lawyers are recruited by Uber-like apps that incorporate user ratings, price comparison and professional options? I can tell you, it'd be like me, don't read them, but maybe that doesn't really work. But as some of the articles in this issue explore, market mechanisms don't always have a deteriorative effect on professional ethics. Hugh Breakey, in his article, cites market forces as perhaps the most important example of ambivalent obstacles or supports. Clients can either vote with their feet and their wallets by casting off unethical professionals and flooding towards those with better standards, or they can drive a race to the bottom of professional standards as the least ethical professionals sell out to the highest bidder. I'm an optimist on that. I've found in my experience that serious corporations are generally conscious of their ethical obligations, and whilst they might sometimes tend to want to ignore them, once they're drawn to their attention, they will comply with them. In John Morgan and Pamela Hanrahan's article, professional indemnity insurance is considered as a regulative force. The authors demonstrate how PI insurance can act both as a market corrective via feedback steps, but also a way of creating moral hazard. One of the interesting things when I was president of the bar was when the professional standards schemes came into operation, whether and to what extent that would limit the regulatory force of those matters, that people advising on issues beyond their competence and sometimes, I regret to say, without regard to their responsibilities, were protected by these schemes. I think that's a problem with PI insurance being a regulatory force, John and Pamela, but I'll be interested in knowing your views on it. In Hughes, Breaky and Charles Sampson's second article, they demonstrate how external regulation in the form of a national exam might stymie positive trends in the financial advice market, such as a demand for greater self-regulation. Now, one consequence perhaps of increased what I'll call client-centrism is the subjugation of the profession's public service function. A theme that permeates many of the papers in this issue is the relationship between the professions and the state. For instance, in Dimity and Thomas Clark's and Justine's article, the absence of a public service purpose is cited as one limitation holding the banking industry back from recognition as a fully fledged legal profession. The banking industry, of course, includes financial advisors. Whether or not financial advisors consider themselves as a profession may be an issue, a matter I don't really want to go to tonight. Whether they behave as a profession is certainly something I don't want to go to, but it really does highlight the issue of professional responsibility. A field of legal advice that I think really highlights this difficulty is the tension between the duty to the client and what I'll call a public service duty is the field of tax advice. Now, we have come a long way, I think, since what Lord Tomlin said in the Duke of Westminster case. Every man is entitled, and all tax lawyers know it, it's ingrained in them from birth, every man is entitled, if he can, to arrange his affairs so that the tax attaching under the appropriate acts is less than it otherwise would be. If he succeeds in ordering them so as to secure that result, then however unappreciative the Commissioners of Inland Revenue or his fellow taxpayers may be of his ingenuity, he cannot be compelled to pay an increased tax. And that approach flourished in this country at least until the 1970s and spawned what might be described as a tax avoidance industry. Now, Sydney-siders now talk about house prices. Let me assure you, in those days, they talked about their Gorton schemes, their Curran schemes, or their substance schemes. It really was only when a Royal Commission, which was set up by the then Liberal government into the Painters and Dockers Union, unexpectedly, and it was quite unexpected, discovered the extent of actual illegal tax evasion that was going on in this country, that attitudes, I think, to some extent changed. But while the Duke of Westminster succeeded in subverting the spirit of the law while maintaining the letter of the law, we now, of course, recognise the matter of statutory interpretation. Legislative is to be interpreted purposefully, where regard is to be had to both, for want of better expressions, form and substance. Nevertheless, and I just pose these questions. Does a duty still remain to advise a client how they can avoid, as far as possible, making what the government regards as a proper contribution? Now, there's a fine equilibrium to be maintained in the interpretation of tax legislation. On the one hand, if the pendulum swings too far in favour of a client-centred approach, where the lawyer actively seeks construction of the law that serves the client and exploits provisions that advance the client's interest in the face of the spirit of the law, they may be caught by anti-avoidance provisions, but for the purpose of this article, is what they are doing appropriate. Now, I talked about what Lord Tomlin said, but shortly thereafter, on the topic of tax planning, Viscount Simon replied, there is of course no doubt that tax planners are within their legal rights, but that is no reason why their efforts should be regarded as a commendable exercise of ingenuity or a discharge of the duties of good citizenship. However, does this moral condemnation of tax planning with its associated priority, I think you'd have to say, of duty to the public, have a place in client tax advice? Does a lawyer who declines to advise on tax minimisation because they are morally opposed to it breach their duties to a client? Alan Myers, QC, an old and good friend of mine, I might say, described in his spirited defence of tax planning advice, there is a distinction between professional ethics and personal morality. He said it in this way: if a person has strong feelings about the immorality of a particular law or of particular conduct, then he should try to alter the law. But it undermines the rule of law if he attempts to inhibit or prevent the citizen receiving advice about the law by fettering the advisor with so-called ethical rules. Now, for barristers, believe it or not, the dilemma is particularly acute. It's compounded by the cab rank rule, which prevents barristers from declining a brief solely on the basis of inconsistent personal views on the subject matter. Is that right in this circumstances or not? I'll let you to ponder it without trying to give an answer. The interpretive approach that is required of tax lawyers is one that has been described as seeking to uphold the publicly legally accessed will, while promoting the best outcome for the clients within those admittedly hazy boundaries. As perhaps a more conservative lawyer, I'd rather describe it as interpreting the legislation, having regard to the accepted principles of interpretation, which I'm pleased to see the universities are teaching more and more these days. But it's a fine line to walk, particularly when the legal subject matter is one that is liable to legitimate interpretive disagreement and, of course, frequent legislative amendment. There's 2 tax acts, and I'm not strong enough these days to carry both of them around with me. But often, aggressive client centrism in such settings is justified by a depiction of the might of the state wielded against the limited resources of the individual. But as with many of our ethical precepts, this picture requires modifying in the case of sophisticated and commercially powerful corporate clients. As Rogers, Kingston, Smith and Cello acknowledge in their paper, most of the safeguards within traditional self-regulation assume the vulnerability of the client. When faced with a sophisticated commercial client, the informational symmetry, which has historically typified the relationship between lawyers and client, can in fact be tipped in reverse. One example of informational symmetry that leaves the lawyer in a vulnerable position is when a client asks for advice on the basis of profit assumptions or sanitised facts. Often in such a scenario, the client is withholding information in order to elicit a particular response. Now, this narrow compass can be in the interest of a lawyer who can claim ignorance of any unscrupulous person, but that's hardly a satisfying ethical position. While it is obvious that wilful blindness is reprehensible, and indeed may not save a lawyer from liability, on the other end of the spectrum, how far should a lawyer have to interrogate the provided facts before giving advice where in circumstance there are no obvious alarm bells? Now, one thing I had on a number of occasions, people will come to me for advice of whether their proposed structure or proposed arrangement would infringe the anti-competitive provisions of what was then the Trade Practices Act and now, of course, the Competition and Consumer Act. You get a set of facts, and it would only admit of one answer, which was the answer the client would want. What do? You can't say that you're instructing solicitors a party to a fraud or a deception. I worked out an answer, which I used to give, on the basis of these assumed set of facts. It's self-obvious what the answer is. The obviousness of the answer makes one doubt the validity of the facts. And people would come to me and say, will you take it out? And I said, no. Maybe that's why I took a judicial career in the end of stuff, 35 years. But really, it did happen a lot, and it wasn't helpful to the lawyer and it wasn't helpful to the client. I hasten to add, neither this firm nor either of the 2 firms for the previous sponsors were ever responsible for that type of conduct. But as lawyers' clients become more sophisticated, and as the corporate action in which they're asked to implicate themselves increases in complexity, the ways of breaching ethical duties escalates in proportion. Much of our just practical advice, probably not lounging, may have fallen into irrelevance. The following prefatory appeal remains pertinent. It behoves the practitioner to take thought of ethical questions in the time of quiet, where they can be regarded as abstract propositions to be decided impartially, without the rights of an injured client to warp judgment or temper it with pity. And that is what I think this issue of the journal achieves. It's an important moment to reflect and promote discussion amongst academics and practitioners alike and indeed judges for that matter, on the changing contours of professionalism and the ways in which we, as a profession, should adapt to best deal with the ethical conundrums many of us face on a daily basis. Thank you.
Well, thank you very much, Chief Justice, for that thoughtful, interesting speech. My name is George Williams. I'm the Dean of the Faculty of Law, and I'd like to begin by thanking the sponsors, Allens. We're very proud of our 3-decade connection, as we are indeed of Ian McGill, one of our alumni who sits on our Law Advisory Council, and we're very pleased that we have such strong long-term partners in this firm. I'd like, of course, to thank and congratulate the authors. You have published one, in this case sometimes 2, articles in a great journal. This journal is recognised in the rankings, in all sorts of places, as being one of the finest in the world, and you can see from the turnout tonight and the quality of this issue exactly why that is. On this occasion it's been enhanced because, of course, it's not just a collection of articles that are born out of a theme, but of something that's born out of a long-term project that's embedded within our faculty, that's being led by our Centre for Law, Markets and Regulation, of which the Director is Dimitri Kingsford-Smith. It's a multi-year project that you see represented in these articles tonight that gives us a sense not only of what's been achieved at this point, but really, as the Chief Justice has alluded to, there's a much larger set of questions that yet are to be addressed. And one of those that we're just starting to look at is particularly how does professionalism apply when it's not people giving advice but automated systems. And if we take the example that the Chief Justice has referred to of tax advice, there's a system, the ALIRA system, that's now being devised for giving automated tax advice. It analyses, it works across millions of documents and answers free-form questions about tax in order to enable you to minimise your tax or take other action. To what extent should that system have embedded within it ethical and other aspects that go to the heart of what we think makes ethical, appropriate legal advice? And I don't think we're even at the beginning of really having good answers to those type of questions. I would say that those systems are now so sophisticated that a person with no legal or tax knowledge could use that automated system and passed a first-year tax exam with 73% quite recently. So that's the point they're at, that they're at the point where they can advise someone with no knowledge at a level akin to a distinction of law students, in that case studying at the University of Adelaide. Of course, at UNSW they probably would have failed, but that's an entirely different story. I would, of course, mention the editors and the people involved in this journal. It is a formidable crew that edits this journal year in, year out, and that is really the bedrock of the reputation. I would like to take enormous credit for this on behalf of my colleagues, my academic staff, but I can't. This is a student-run initiative, and we're proud of the fact that it is exactly that. And I know the advisors have been thanked, and they play an important role, but it really is the students that take the credit for this. It's a monumental achievement producing something like this as often as they do. It's akin to a book, but it's much harder than a book because you've got to cajole people who perhaps aren't used to sometimes writing in this format. You need a certain level of quality to be produced, and it's done based upon a group of people who form a very strong bond of camaraderie that's forged through late nights, a shared sense of perfectionism, and certainly a shared passion for the Australian Guide to Legal Citation. It's a strange group of people, but nonetheless form connections that often last a lifetime. Indeed, it's great to hear Ian talking about his memories of editing Volume 3 all those years ago. It's something that tends to stay with people for a long time. And I'd just like to finish also by saying from my own area, this has a lot of resonance for me, the topics that we've talked about tonight. As a constitutional lawyer, as someone who works as a barrister and also as an academic, I'm constantly faced with this issue that the Chief Justice has talked about, the lawyer as gatekeeper. And in my case, it's often faced with politicians wanting advice when there's a hung parliament. And I can tell you there is very little in terms of what a politician will not do in terms of getting the legal advice they want on who should govern when there's a hung parliament. And it makes it very, very challenging as a lawyer, as it does in other issues. Another issue I advised on was the legality of the war in Iraq in 2003. Again, opportunism and other issues coming to the fore involving issues of great moment that really put to the test someone in my field, your capacity for professional, impartial advice. So these are issues that I know personally are very important. I'm looking forward to the work being extended to other areas, technology and other fields. I'd like to thank you for coming tonight. We're proud of the journal, we're proud of the authors, and we're particularly proud that the Chief Justice has given us such a fine speech tonight. Thank you.